So what happens if I don't attend my hearing? You know, I see both sides of this. I see people who are struggling to get to the court hearing, and I've also been on the other side where it's frustrating when people don't attend. So here's where the court is, because let's be honest, that's the only opinion you really care about here. First of all, when a court sends out a court order and there's a hearing date, it is not a suggestion, it is not a mild suggestion, it's a court summons. Courts take a really dim view of people who just don't attend. Now, listen, there could be a million reasons why you can't attend. Childcare is often cited as one of the most popular reasons as why people can't attend. You know, if the court has a hearing in half term or a school holiday, or whether you work and you just can't take the time off and you can't sort that childcare out, or maybe it's because you've had a relative pass away, or you've got a sick relative and you need to attend them in hospital. There's got a whole bunch of reasons. I mean, last week I had someone who wanted not to attend court because they had a work course, or their employer was a bit reticent about giving them the time off to go to the court hearing. Whatever your reason is, the rule of thumb here is that you have to attend the court hearing. And if you don't, courts can and do make orders in your absence. Now, I know for some of those people who are on the opposite side of this says, well, I don't know, I turned up and the court didn't make any order. True. Courts tend to err on the side of caution. So what probably would have happened in that case is that the court clerk would have probably phoned the ex to see where they were. Sometimes, people get stuck in traffic. Sometimes there's an accident. And I had one particular case where there was a huge pile up on the motorway and generally physically couldn't get to court, or maybe they've been literally out of the country. But even that, nowadays, that's not an excuse, because a lot of the courts could transform that hearing into a virtual hearing. So my pro tip here is that whatever the reason is, the court will only consider adjourning a court hearing, first of all, if both parties agree. So you're going to have to actually ask. It's not an option for you to just simply not attend, because you run that risk of the court making an order in your absence. You can't bank on the fact that the court is going to err on the side of caution, because it depends who you're in front of. I mean, I've been in front of judges or magistrates who are very lenient and say, well, let's just give this person the benefit of the doubt, let's adjourn the hearing, let's have it at another hearing. Or I've seen the opposite. I've seen court clerks consistently phone. I have seen judges make orders in the absence of people. And listen, if you're somebody who just, for whatever reason, decides not to engage in proceedings, well, first of all, that's not really an option, because at some point that has got a shelf life. Just want to put that out there. If you feel like, look, I'm done with this for whatever reason, ill health, childcare, the application shouldn't be made in the beginning. It doesn't matter what you think, or maybe you think the system is biased. It doesn't matter what you think. If you're not engaging in proceedings, that has a shelf life. And at some point, even the most lenient of judges or the most lenient of bench of magistrates will make an order in your absence, and it probably won't be what you are looking for. So first of all, ask the other side. There could be a genuine reason as to why that hearing can't go ahead. You never know. The other side might agree to the hearing being adjourned, and courts, if both parties are agreeing to a hearing being adjourned for whatever reason, maybe a report has been due in late, or whether it benefits the other side actually for a hearing to be adjourned. So never think that you know the answers to it all, because you don't know what the other side is thinking. So ask. Number one, ask, because if the other side are in agreement, then you will get that hearing adjourned. If the other side are not in agreement, you might have to put an application in. Now, sometimes you can do this request by email or letter, but you're going to get some courts, and listen, I deal with courts all across the land, and they differ, they vary greatly. Some are quite pedantic and will want you to fill out an application form with a fee, to ask for that hearing to be adjourned. So be prepared to do a little bit of paperwork, and you're going to have to back up what you say. If there's a medical reason, for example, look, just do yourself a favour. If it's a medical reason, get a letter from the GP to show that you're not able to attend the hearing. And I have seen that. I've seen some people in some horrendous physical states, or they've gone through surgery and they've had a hearing and the court's just gone ahead with the hearing. And really what needed to happen is that an application needed to be put through, and perhaps a letter from the doctor to say, look, this is wrong, and this person can't attend a hearing. Just making life easier for yourself, because what you don't want ultimately is a court to make an order in your absence. And if they're going to do that, they're going to do something that's not what you want. Guys, I hope that has helped. Drop your comments down below. I want to know, are you the person that just thinks, oh, I just can't make it, I just simply can't make it? Or are you the person that's happened to, and you said, well, my ex is just not attending any hearing, they're just not engaging in the process? Let me know in the comments below. Guys, I hope that has helped. Have an amazing rest of your day, and I'll check you later.